Good morning, afternoon, or evening, everyone, and welcome to today's webinar hosted by AIPPI, the impact of affirmative action rulings on DNI programs. My name is Idalla Brum, and I have the great honor of serving you as a moderator for this important and timely discussion. Recent legal decisions, particularly in the US, have challenged long-standing frameworks supporting diversity, equity, and inclusion. These shifts have triggered global conversations not only about compliance, but about values, mental health, workplace culture, and the future of inclusive practice across industries. Today, our panel will reflect on the legal impacts of affirmative action rulings, the evolving DNI landscape across jurisdictions, strategic responses from law firms and institutions, and the human side of these challenges, including resilience and well-being. But before we start, I have some notes to tell you. This webinar will be recorded and published on AIPPI's YouTube channel. Feel free to catch up on it later. Questions to the speakers can be submitted via the Q&A box, and they will be answered by the end of the webinar. There is a brief survey after webinar, and please, we ask you to fulfill it, and thank you for your feedback. To begin, I'm truly delighted to welcome our distinguished speakers, Lisa Mueller, Julie Shin, Cedric and Korukottu, each of whom brings rich legal expertise and deep personal commitment to DNI work across different regions and industries. To start, we have the amazing Cedric. He's our first speaker, and I'll have to make a small introduction about his bio. Cedric is a solo patent practitioner at the Who Law LLC. He holds a PhD in analytical chemistry and has worked in both private practice and in-house roles, including as a patent attorney at Eli Lilly. Cedric also serves as AUTMS Strategies and Competitive Innovation Committee, and his work reflects a strong interest in oncology, innovation, and equitable access to an IP system. Welcome, Cedric. Feel free to start your presentation.
Thank you, Idalla. I really appreciate that introduction. And thank you so much for this opportunity to present. Let me see if I can switch to my presentation. Can everyone see it? Okay, great. As we talk about the impact of affirmative action rulings on DEI programs, we're going to focus more on workplace discrimination, though the Supreme Court most recently addressed affirmative action in terms of admissions, college admissions. So we'll start from that as a basis and then work through that case and how it talks about workplace discrimination. Just kind of give you guys a framework of what we'll discuss going forward. There we go. All right. So to start off, we have students for fair admissions. We'll just be talking about this as SFFA. In this case, by the U.S. Supreme Court, they're effectively seeking to just do away with all governmentally imposed discrimination based on race. You may be very familiar with strict scrutiny, especially if you're a U.S. attorney. You can probably bring back some memories of law school days, or the bar at least, where it has two parts to it. The first is you would have to have a compelling governmental interest, and the second is that the government's use, specifically race in this case, would need to be narrowly tailored. So those terms are things that would definitely have come up on the bar exam at some point. The U.S. Supreme Court looked at the admissions process for Harvard and University of North Carolina and rejected both of them. Now remember, this is Title VI of the Civil Rights Act, while we are talking about, per DEI, Title VII, which comes up in this SFFA case in more detail later. The Supreme Court in SFFA did cite a couple of examples of when there was a compelling governmental interest. Specifically, as stated on the screen, they're remediating specific identified instances of past discrimination that violated the Constitution or statute. and avoiding imminent and serious risks to human safety in prisons. Now, I cite that again just because we'll be talking about that later on in part of my presentation. Yeah, went way too far. There we go. Okay, so SFFA looked back at a previous case. And the reason why I wanted to highlight this case as well is to talk about why are there so few examples of affirmative action that meets this strict scrutiny test. As you can see here, this university admissions for University of California was restricted to just one justification. The only justification that was met was the obtaining the educational benefits that flow from a racially diverse student body. There were several other justifications that were found to not be compelling. As you can see, they're reducing the historic deficit of traditionally disfavored minorities in medical schools, remedying the effects of social discrimination, and the increase in the number of doctors working in underserved areas. All of those were found to not be compelling reasons. In addition, Bake also found that you can't have quotas in terms of race for college admissions, or sorry, this is medical school admission. It can only be considered as a plus in an applicant's file, which is something else that is discussed in other cases. There we go, that works. All right. So now, if you looked at the date of Bake, that was 1978. There's another case, Grutter, it's 2003. And in Grutter, the race-conscious admission programs were stated to have a termination date. There had been about 25 years between Bake and Grutter. And if you look at Grutter to today, 2003 to 2023 is when SFFA was decided. You have another 20-year period. And so SFFA picks up on this. And what you can see here is that the Supreme Court is pretty much dead set on terminating any and all forms of race-based affirmative action. It doesn't seem as if there's going to be a way that you'll be able to have race-based affirmative action that the court will uphold. They give a number of reasons here and say, when is a court to know when these commendable but non-compelling justifications have been reached? When will this perilous remedy of racial preferences cease? And they say they can't really point to anything. There's no point where it should actually continue on. Now, okay, so all the cases that we've talked about up to this point have been Title VI in terms of admissions. And now SFFA has some comments in it related to workplace discrimination, which is closer to the DEI programs that the purpose of this discussion today. Now, the court acknowledges that courts can ask whether a race-based benefit makes members of the discriminated class whole for the injustices they suffered. And then they also talk about how the burdens shifts very quickly from the complainant to the alleged discriminatory employer. So you can see from the Supreme Court in this SFFA case that they are really setting up to terminate workplace discrimination based on race. I think they're really just looking for the right sort of case to come in front of them, seeing how they've structured the arguments here in SFFA. One of the justices explicitly talks about Title VII. And you can see a couple of the citations here on the screen. It sounds familiar. He makes the mention that Title VII is just next door to Title VI on the Civil Rights Act. And so he also makes mention that Congress used the same terms in the same statute. They should give the same meaning, clearly leaning toward applying this SFFA framework to any forms of workplace based or race-based workplace discrimination programs, as DEI programs have had in the past. But is there evidence that there is still workplace discrimination? And would the Supreme Court consider DEI programs based on race if it were remediating a specific identified instance of past discrimination that violated the Constitution or statute, as SFFA stated as one of the two examples of when affirmative action was met? Unfortunately, I just don't think so. There are a plethora of books that discuss, specifically like this one, The Color of Law, that discuss African-American discrimination. And it doesn't seem as if the court would consider any of those bases, even these explicit governmental policies, to be sufficient, given that, this is a book from 2017 and SFFA was decided in 2023. You don't have to look hard to find evidence. As we talk specifically about the legal sector, you don't have to look hard to find evidence of a deficit of traditionally disfavored minorities in the legal sector. I just picked up this article just because it had a nice, concise paragraph, and it just listed out all of these areas where it shows there's an underrepresentation of minorities in law school, as practicing lawyers, working in corporate firms, and there's an explicit statement they face subtle and not so subtle discrimination. Very easy for someone to use, the plethora of articles and data out there to build an argument that there is some form of a DEI program that could be race-based, and present that to this all the way up to the U.S. Supreme Court. It's just that it just doesn't seem as if that would be something that the court would find to be compelling. In Bake, as we talked about earlier, previous slide, the Supreme Court then stated that reducing the historic deficit of traditionally disfavored minorities, in particular medical school in that context, was not a compelling justification for race-based affirmative action programs. There are forms of past discrimination. Because this is AIPPI, I thought some patent-related data would be appropriate for this conversation. Lisa Cook wrote about the relationship between violence and economic activity and used patents as a way to gauge economic activity. Her paper found significant declines related to shocks in the law, rule of law, specifically race riots, lynchings, as related to economic activity. You'll see in figure 1 here that this period is related to after the Emancipation Proclamation of 1863 and before the Civil Rights Act of 1964. And you can notice that there's an uptick in the number of patents per million for African Americans between approximately the years of 1885 and 1900. If you look to the next slide, this is a slightly different set of data. So figure 1 showed grand patent data. This figure 2 shows applications filed data. But what's clearly shown here is that you see a lack of race riots between like 1880 and just prior to 1900. That seems to at least correlate very well with an uptick in the number of African-American applications that have been filed. Would this be something that the Supreme Court could use to find compelling? It doesn't seem likely. This is data that's already known, it's already out there. I don't know if this is anything that's been brought to the Supreme Court's attention explicitly, but it just doesn't seem as if it would work. You can see that even something as horrendous as the Tulsa race massacre which is something that I didn't learn about in school. I didn't learn about this until reading Lisa Cook's paper. This is something that has happened. It happened in 1921. It happened over 100 years ago. And still, there's been nothing done. No individual, city of Tulsa, the state of Oklahoma, the federal government, none of them have done anything related to this massacre to try to seek justice for those that experienced this. There's still 2 survivors left. And recently, their lawsuit was dismissed by the Oklahoma Supreme Court. And in their brief, their attorney stated that there's no going to the U.S. Supreme Court on this. So really, there's definitely a chilling effect on the Supreme Court, seeking to rectify even such specific identified instances of past discrimination that violated the Constitution or a statute. On the bright side, there are mechanisms out there where you could, if your DEI program does consider race, there are mechanisms out there to at least gather data to make as strong a showing as you can of a compelling justification. If you do get in front of the U.S. Supreme Court, that they can at least consider it. The USPTO Success Act provides background data to argue for justification of race-based DEI programs. Granted, this data is not perfect. It's based upon inventors and not employment data. But you could use something like the USPTO Success Act as a model to collect data for your industry to support your DEI program and use that as the basis for justification. USPTO Success Act does reference who becomes an inventor in America, the importance of exposure and innovation. It's an article by Alex Bell, and this is relevant data that the USPTO found to be compelling to bring forth the Success Act. And you could also use this sort of Alex Bell's model as another way to gather information for your industry. Hopefully that's helpful in one shape or form or another. So that's it from my part of the presentation. I now hand it back over to Idalla to introduce Lisa. And thank you so much. We'll take questions at the end, I understand.
Congrats, Cedric. It was perfect. The data you shared is quite interesting as looking from a Brazilian perspective. So maybe I'll have some questions for you later. So now we are going to listen to Lisa, our sharing the DNI committee. Luckily for us, Lisa is a shareholder at Casimir Jones and a globally respected voice in the fields of pharmaceutical, biopharmaceutical, and plant patent law. She's the author of the Patent Panorama blog, host of the AUTM on the Air podcast, and has been recognized as the WIPR Diversity Champion and an IM 1000 honoree. Lisa brings deep insight into how affirmative action rulings are impacting U.S. law firms and beyond. Let's go, Lisa.
Thank you so much, Idalla, for that really kind introduction. And I am going to go ahead and share my screen. Hopefully everyone can see that okay. Hopefully, let's see. There we go. All right. So as Idalla mentioned, I'm going to talk about the impact of some of the court cases that Cedric just went through, and that presentation was really excellent along with all the data. Cedric talked a lot about the Students for Fair Admissions case, and just by way of background, for those of you who may not be familiar, the Students for Fair Admissions is a nonprofit, something we call a 501c3 here in the U.S. And it was founded by an individual named Edward Brum. And as you saw, the whole idea behind this nonprofit was to challenge admission policies at universities. Well, Mr. Brum has a number of other nonprofits that he founded as well, one of which was called the American Alliance for Equal Rights, also known as AAER. So after the Students for Fair Admissions decision came down, Mr. Bloom and his AAER non-for-profit then decided to target law firms. So right after the Supreme Court decision, which I think was in May or June of 2023, he filed lawsuits against the law firms Perkins Coie and Morrison and Foerster, targeting their diversity fellowship programs as violating a very old law related to guaranteeing equal rights in contracts. And these programs, these fellowship programs that Perkins Coie and Morrison Foerster had, they were to incentivize people who are Black, Hispanic, part of the LGBTQ community, or people with disabilities, to apply to their firms to try and increase the number of diverse individuals practicing law, which, as you saw from Cedric's slides, these groups tend to be very underrepresented in the legal community. Both firms ended up changing their fellowship programs as a result of the lawsuits, and the suits were ultimately dismissed. And after that, we saw a lot of law firms who had similar type of fellowship programs also make changes to them in view of these lawsuits. So that was in 2023. And then we had a change of administration, as I know everyone knows, in January of this year. The next thing we saw was very quickly after the Trump administration came into office in February and March, we saw President Trump issuing executive orders against certain law firms, 5 in particular, that he deemed to be dishonest and engaging in litigation and conduct that he believed was detrimental to American interests. And the 5 firms you see listed on the screen here. And essentially, his argument was that they either provided legal services to various individuals like Jack Smith or Robert Mueller, who were investigating him either with respect to Russia or bringing criminal charges based on his first term, or were involved in what he claimed to be manufacturing information designed to steal the 2016 election, or brought legal services or provided legal assistance against protesters who stormed the Capitol in January 2021. He also claimed dissatisfaction with a lot of these firms' DEI policies as well. So as a result of these executive orders, what they moved to do was the government wanted to terminate all their contracts that these firms had with the government. They suspended their security clearances, they barred them from federal buildings, and prohibited government employees from engaging with these firms. 3 of the firms, Perkins Coie, Jenner and Block, and Wilmer Hale, all sued and won permanent injunctions against the government. Not surprisingly, the federal judges found that these executive orders were unconstitutional. But there was a firm, Paul Weiss, did settle, and as part of the settlement, they agreed to provide over $40 million in pro bono legal services during the course of the Trump administration as in support of various initiatives, which were kind of very loosely defined. They also committed to providing merit-based hiring and promotion and agreed they would not pursue any DEI policies. So you start to see some of the chilling effect that come into place immediately after the Trump administration comes into office. Well, on the heels of these executive orders against these firms, in March 2025, the Equal Employment Opportunity Commission, which is part of our U.S. Government, sent letters to 20 prominent big law firms asking for data on their DEI programs and information about whether or not they were involved in any discriminatory hiring practices related to those programs. And the information they requested was really broad. If you read some of the letters, they were very lengthy and requested a lot of information. And that information included things on their internships, their scholarships, their fellowships, and their hiring programs. 9 of the law firms settled, and you see which ones those are there. And in total, they agreed to provide a huge amount of free legal work, over $500 million, for a variety of causes, including Veterans Affairs and combating anti-Semitism. There are still firms that are who settled, who are very confused about what exactly they are supposed to be providing in terms of pro bono work, as the Trump administration hasn't really defined what that is. More importantly, they also agreed to disavow any of their DEI programs, which of course the government feels are illegal, and would accept clients regardless of political beliefs. And you can see for the firms that settled, the EEOC released a statement saying that they hope these firms will be leaders in their industry by eliminating these programs and returning to merit-based equal employment opportunity for all. So that's what's been happening here, and it leads to the question as to what has the impact between the Students for Fair Admissions case, the executive orders, and then the letters targeting the 20 big law firms from the EEOC. Well, it's been pretty significant here. A number of law firms, not surprisingly, in view of what's been happening, have just abandoned or dramatically scaled back their DEI programs in response to political pressure and the scrutiny from the EEOC that came from the Trump administration. So we've seen some really large law firms that have completely eliminated their DEI programs. Firms like Reed Smith and White Case, they have just decided to retire, so to speak, their DEI programs and provide other offerings. So for example, Reed Smith, who was considered a gold standard firm by Women in Law Empowerment Forum, has changed their DEI program to provide offerings under what they call culture and engagement. White Case continued all its DEI programs. They are a large firm with 44 offices globally, almost 3,000 attorneys, and they have replaced their diversity initiatives with various types of professional skill training and engagement programs. So you can see that has been a kind of a common thread through a lot of particularly larger law firms. Another impact of these court decisions, executive orders, and this regulatory scrutiny has been the dissolution of a lot of affinity groups. Firms like DLA Piper and Skadden Arps, they have done away with their affinity groups. And you can see DLA Piper eliminated theirs the day after the EEOC letters came out. Skadden had a lot of affinity groups, at least 10, and they have been completely shut down, and all reference to them has been removed from their website. There's been a lot of rebranding amongst law firms as well, and label changes. References to diversity, equity, and inclusion programs have disappeared off of a lot of firm websites. Some of them have replaced them with things like Kirkland, which is has a new web page promoting a welcome environment. K&L Gates has changed and removed diversity and renamed its Diversity and Inclusion Committee to Opportunity and Inclusion. Latham Watkins has basically taken its DEI webpage and rerouted it to a page that is called or entitled You Belong As You Are, and they've removed all references to institutional racism on their site. And then Sidley, like a lot of other firms, had chief diversity, equity, and officers, and a lot of firms have renamed those positions to chief inclusion officers. There's also been a broader industry impact, not just on law firms. We've even seen the American Bar Association that's delayed enforcement of its law school diversity rule. It received pressure from the Trump administration, so now it's delayed implementation of that rule until next August. I suspect they are going to keep delaying its implementation for a couple of years until we have another administration change. And then we have the Skadden Arps Foundation. For those of you who may not be aware, Skadden Arps founded a foundation back in 1988 on its 40th anniversary, to provide 2-year fellowships for individuals who are interested in public interest law and helping people who are living in poverty. They have changed their application criteria to remove language relating to racial justice and eliminated requirements that address racism in their work. And very recently, after Skadden settled with the EEOC, the head of the Skadden Arps Foundation resigned in protest. There are some bright spots. There are some firms that have maintained their DEI commitments. You see 2 of them there, Stinson and Alston & Bird. We've also, as I've alluded to before, seen changes that have had financial and operational implications. So many firms had DEI staff positions. Those have been eliminated. As I mentioned, employee resource affinity groups have been disbanded, and many no longer participate in external DEI surveys as well. So just a quick note, what about the firms that settled with the Trump administration, either on the executive order side or the EEOC side or both? There has been significant backlash from not only the legal community, but clients as well. First of all, a lot of these firms have seen a loss of attorneys who are very upset with the settlement with the government. For example, Paul Weiss has lost 10 litigation partners, including its partner that did debate prep with Kamala Harris last year. We see a loss of work. The New York Times is reporting that Microsoft recently dropped Simpson Thacher in favor of Jenner because it did settle with the government. And there are firms that are anonymously stating, those that did fight the Trump administration, that they are seeing clients drift away from the firms that reached settlement agreements. Clients have lost confidence in those firms that settled because the perception is, and I think it's right, that they were not interested in defending or made strategic decisions not to defend the rule of law. And then finally, we're seeing some law student boycott as well. Some students from elite law schools are really thinking twice about where they want to go and where they want to seek jobs. Many of them are not interested in pursuing jobs with firms that struck deals with the government. So that is the end of my presentation, and I'm going to turn things back to Idalla. Thank you all very much for your time.
Thank you very much, Lisa. It's interesting to see how freedom is changing in the US, especially DNI. So now that we have this US perspective, we have now the opportunity to listen a little bit more about Europe and Asia. We'll start with Jag. Jag is is a partner at Greenacre, a Munich and a European and a UK patent attorney with advanced degrees in physics and biological and biophysical chemistry. He handles portfolios in these respective technologies and is a passionate advocate for inclusion in the IP profession. Jag is active in organizations like AIPPI, INTA, and AIPPI, and mentors early career professionals across Europe. So Jag, now that we heard about the US, what's going on over there, I have some questions for you. So let's start. What do your recent rulings by the European Court of Justice say about affirmative action, and how do they impact DNI initiatives in Germany? Additionally, since the US affirmative action rulings, what reverberations have you felt in European and particularly German DNI conversations? And last, what does the current EU&I German legal framework for positive actions look like, and how it is distinctive from the US model?
Well, thank you, Idalla, for a kind introduction, and also thanks Cedric and Lisa for giving us the US perspective in detail. Let me switch now to European and let's say a little bit of German perspective. I don't have a presentation, but I will try to address the points raised by Idalla. So first, how these rulings in US, the affirmative action, have impacted DNI initiatives in Germany? Well, when there is a chill in Boston, of course, somebody gets cold in Bavaria, right? And this transatlantic echo was immediate because many European German corporates, they do operate campuses in, for example, Texas, Michigan, or any states in the US. And therefore, the first thing to note is that the legal weather system in EU is, or in Germany, is different. So the European Court of Justice had made it clear that affirmative action, or in Europe it is called positive action, is allowed under EU law, but only within narrow tests. That is, if it meets 3 key conditions. It must be proportionate, meaning the measures must be carefully balanced and not excessive. It should be transparent, so the criteria and goals are clearly explained, and objective, meaning the decisions are based on solid evidence and not on personal opinions. So as a result, organizations are shifting from rigid quotas to soft targets and supportive measures like bias-free recruitment processes, diversity training, and transparent evaluation criteria to stay compliant while still advancing DEI goals. For example, picture the EU landscape as a 3-act play, right? In 1995, there was a Kalanke judgment where it said the promotion rule for women was struck down for ignoring individual merit. And then came the Marshall judgment, which allowed a tiebreaker preference when candidates are equally qualified, so that an individualized merit check is retained. So the positive action is permitted, but only with safety rails against automaticity. The German law has long prohibited direct race-based distinctions, so German corporate DEI playbooks already emphasized structural and rather than strict racial levers. What this means is that German HR heads were asking whether the voluntary targets could expose them to US litigation, and if they shared training modules globally. In response, many firms or corporates ran a passport split that US sites trimmed racial goal language, while German sites doubled down on existing obligations such as gender quota for excessive boards, which was a statutory requirement mandating at least one woman on executive boards of large listed companies. And these were unaffected by the US ruling. At the EU level, the debate actually accelerated the movement. I think as we speak that there was a women on boards directive, which obligated listed companies to hit at least 40% representatives in underrepresented gender. So the message in EU was, if the EU is pulling back, if the US is pulling back, then Europe must show that lawful positive action can still thrive. So we can all agree that for DEI initiatives, there is a greater need to demonstrate that the programs are fair, necessary, and legally sound. So what this also meant was that the US decision triggered a compliance audit reflex as a consequence, but it also highlighted how Europe's rule of law architecture gives corporations legal certainty to keep pursuing inclusive outcomes, so long as, as I said, the measures are proportionate, transparent, and objective. The bigger takeaway for German organizations is to translate global DEI narratives into local vocabulary. So I don't know how many are in the audience are known about the German language. It's Gleichstellung und positive Maßnahmen, rather than abandoning the complete effort. So even the German law itself says that the state must promote the actual implementation of equal rights for women and men, and does not merely allow positive action. It arguably mandates it in certain context. So this basically means that if programs appear too broad, too vague, or overly preferential, they may face legal challenges or lose public support. But programs must not only be morally sound, but also legally robust. Idalla.
Perfect. Thank you, Jai. I have two more questions for you. Especially, I have a lot of questions. But the next two is like, what are the major DNI challenges in the legal sector of Europe and Germany, and what trends are emerging? And or given heightened legal and political scrutiny, what practical strategies are German employers using to keep DNI programs both compliant and effective?
Yes. So before I go into my answer, I just want to reflect on what Cedric and Lisa said about data, stronger use of data, which I will come soon. This is what we see as an emerging trend in Europe, that they use now stronger use of data, clearer documentation, and consistent review of outcomes. This basically means that the Europe will keep up with these transparent, proportionate, and objective measures. And now, what are the challenges? So across Europe, the legal profession still faces significant barriers to true equality, despite, of course, more women, ethnic minorities, and LGBTQ professionals entering the field. Leadership roles remain largely inaccessible to many. The traditional law firm structure or corporate structure, with its long hours, rigid hierarchies, and cultures, and often favor the status quo, still creates, one may call, an invisible wall, which many struggle to climb over. So, but we see some changes. So we see a shift in the growing link between this DEI goals and leadership performance. This is a big step because it signals that accountability is no longer optional. It's becoming a core part of how success is measured. At the same time, we also see a little bit of rebranding of DEI language, especially in countries like Germany. For example, in a startup, they feared their scholarship for first generation tech students might breach new US legal norms because the beneficiary pool was predominantly female migrants. Rather than scrap the scheme, they reframed the eligibility lens from identity to barrier. For example, socioeconomic status, first in family attendance, refugee background. Suddenly, the program met both EU proportionality test and also sidestepped US race concerns. Firms are also shifting from explicitly talking about diversity and inclusion to using terms like culture, well-being, or belonging to reduce political pushback while maintaining core commitments. So three broader tactics are emerging. One is the metric shift from quotas to gap closing. Instead of headcount targets, firms benchmark barrier metrics, example, time to promotion differences, retention by parental status, thereby aligning with the EU Pay Transparency Directive, which forces disclosure when gender pay gaps exceed 5%. And the second is the compliancy by design. So policies are drafted with a double column table. So one with this on the left, German EU legal basis, and on the right, US requirements of 1981 exposure on the right. So this front loads legal review and avoids panic-driven rollbacks. And the third is this narrative localization. DEI storytelling now foregrounds constitutional equality and economic competitiveness, themes that resonate with German Works Council rather than US social justice language. For example, several German companies rerouted training budgets into inclusive leadership academies that teaches bias-free algorithm designs, a skill-based angle, which no court may likely strike down. So the result is more data-driven. So again, which coming back to Cedric and Lisa's point, the DA architecture that survives legal headwinds because it hardwires fairness into process instead of pivoting on protected class headcounts. So in other words, make inclusion the engineering spec and not the after-sales accessory. So the challenges are clear that they have to ensure that accountability translates into real meaningful change and not just box ticking. But then the challenge is to maintain these core commitments of DI while adapting the language it is used. How to keep the substance without losing the message? Of course, this is a unique challenge, I'm sure also in many other jurisdictions, not just advocating for inclusion, but providing practical tools and guidance that help embed it deeply and sustainably, even when language around DI evolves. We have seen that a lot evolving around DEI. That backdrop, maintaining the effective DEI programs isn't just challenging, it's imperative. But to stay effective, I have seen many organizations which I advocate integrate DEI into their core systems. For example, how the leaders are evaluated, how teams are structured, and how advancement happens. So this not only makes initiatives harder to undo, but also reinforces them as a part of how business is done. So what to summarize, I think the language has been the strategy here, reframing the DI terms into culture, belonging, which might reduce some resistance, so long as we stay honest about the intent, right? Without, of course, compromising the values. This, of course, provides the legal or circumvents the legal uncertainty, especially across jurisdictions. So ultimately, even if legal and political contexts keep shifting, there has to be continuing agile and work towards making a DI framework for fairness and not seen as a risk in Europe. So this has been the challenge, and I think we may see more data-driven approach to address and even tackle DI programs in view of this affirmative action in the US. Idalla.
Perfect. Now we still have 5 minutes to go, and I'll just make the 3 last questions into a big one, and you can manage how to answer it. And what mental health risks can arise when DNI policies are rolled back or weakened, and how can employers respond? Or what mental health and workplace culture consequences arise when DNI is challenged, and how can German employers build resilience? And last, what inclusive approach should organizations and associations adopt to address today's complex DNI challenges, such as migration and LGBTQ plus rights, especially in evolving contexts?
Well, I will try to be quick, given Julie's time. Of course, this is a question that often doesn't get asked, but it should. DI is not just about representation, targets, or compliance report. It's about how people feel. So when DI programs are weakened or paused, the message received by marginalized professionals isn't just organizational, it's deeply personal. For example, it triggers anxiety. People ask, do I still belong here? Or people feel like, why the floors keep shifting? So it will have direct and indirect negative effect on mental health. I think European data supports this anxiety, but there has been evidence showing that German employers are now adopting psychological safety pulse checks. For example, they make short surveys, anonymous surveys to see or to flag any micro stressors. And also adding counselors who speak non-German language so that the small or the community feel belonged, and also narrative repair. So leaders now share personal stories, how they grabbed the class, migration. For example, I speak quite often in many communities here, promoting not just DNI, but just the belonging. So there has been recognition that the inclusion and mental health are linked and are closely tied. So associations need to step into, like associations like us, right? Also need to step into close this gap. And when organizations pause or dilute, it's often us, like AIPPI, can offer continuity. And of course, storytelling and advocacy still matter. So we can't allow the narrative to be hijacked by fatigue. We have to highlight the human impact, how shifts in policy affect real people's life. This is a powerful way to re-enter the conversation around empathy, especially in legal and corporate environments where I think emotional nuance is, I think, often overlooked. People think if you share your stories, it's soft. And about this LGBTQ, so I think there has been now refugee integration and LGBT inclusion, but this most largely plays the employers and even lawyers play a key role because they craft clear centric policies that preempt any equal rights and counsel role and offer pro bono roles. So the takeaway is attorneys can de-risk inclusion by embedding compliant wording, train managers. So the way forward is to retreat, but to recalibrate and staying as human as possible to your co-workers. Thank you.
Perfect, Jag. You're awesome. Thank you for your insights about it and the European perspective. Now we're changing our perspective to Asia, especially with Julie. Julie is of counsel at Jones Day in New York with vast experience in IP litigation, transactions, and regulatory issues. She has advised clients across industries from biotech to consumer electronics, and has also served as a senior legal counsel at a multinational corporation in South Korea. Julie brings an international lens to DNI and mental health issues in legal practice. Hello, Julie. To start, I have a first question, and I'll just ask it, and then you feel free to start. So, how are the recent affirmative action developments in the US perceived, and how are they impacting DNI programs and initiatives in Asia?
Thank you, Idalla, for the introduction, and I will try to attempt to add some dimension from Asian perspective, from my experience. And I think the discussion topics from other speakers, from Cedric, Lisa, and Jack, those are good guidelines and good lessons for Asia, because these are, the DEI initiatives and DEI considerations are relatively new in Asia. So I think they provide good guidance and roadmap for Asian countries as well. But I think to start, maybe it's helpful to explain, start by explaining the unique challenges that these countries, Asian countries, face as to DEI programs and initiatives. Especially, I think I can focus on especially on Korea and Japan. These are very, very homogeneous societies, homogeneous cultures. So I think they have very unique challenges in implementing DEI programs because of that homogeneity. And these are the societies that are traditionally, culturally and ethnically homogeneous, and also very deeply hierarchical. So the populations in these countries are homogeneous compared to other countries, and historically, there also have been great emphasis on conformity in these societies, and these traditional social and societal structures in these countries, and the deep hierarchy in these countries based on age, seniority, and education background, those kind of provide challenges and barriers to DEI considerations in these countries. And because of this background, I think DEI programs in these countries have been so far rather superficial. So there are recognitions that DEI programs are needed, and especially demand from multinational corporations and from education sector. But still, there have been more awareness and more initiatives for DEI programs. But and that comes especially as to gender background. But these countries are late starters on DEI, and I think there has been, because of this cultural and historical background, there has been a lack of strong leadership and commitment on the DEI front. So that has been the challenge. And in terms of the legal framework too, the laws and legal framework are lagging behind from more detailed and more developed laws in the US and Europe, in Germany that Jack mentioned, and in the US that Cedric and Lisa explained. So if you're looking at Korea, although there have been some cases relating to diversity and equality, in the context of sexual harassment, there's no anti-discrimination laws in Korea. And I think that's the case in Japan as well. So there have been voices that there should be anti-discrimination laws implemented in these countries, especially considering the current trend and the immigration status, and more mobility across the globe. But there have been some resistance to broad anti-discrimination laws being introduced, and these laws are yet to pass in these countries. So I think for younger generations, I think they have more exposure and more openness to diverse culture, language, and background. They get all kinds of exposure through the social media, the YouTube, and the internet. So they have this background and knowledge, but I think the inherent challenge remains in that they are living in this very, very homogeneous society and being educated in this education system that lacks diversity and inclusion. So that's the big challenge. And in the legal profession, I think I see more diversity in recent years. In Korea, for example, Korea introduced law school system that's based in the U.S. law school system about 10 years ago. And since that system was introduced, before that, lawyers were educated in college and then took the bar exam. Now after college, they go to professional law school. And I think that with that change, I see more diverse backgrounds in attorneys. I think there are more students going to law schools with more diverse backgrounds and attending law school and becoming attorneys. So I think the legal profession is becoming more diverse. So coming back to your question of how affirmative action decisions and all these developments are impacting Korea, Asia, and other countries, so far I do not see any visible impact on DEI initiatives in these countries. I don't think there's any real change yet, but I think these decisions and developments are raising awareness and making people think. So there's more interest, and there's different dimensions and different perspectives that are being brought on beyond what people have thought in the past. So I think it's making people think more, and what's the best way to promote diversity. And I think hopefully Asian countries will also progress further on that front as well.
Oh, nice. And I know that you gave us a broader perspective, but are there unique challenges for DNI in Korea, for example?
Yes. So exactly, on the point that I mentioned already, the societal challenges, the cultural challenges, the customs, the history. So I think despite all this recognition regarding the need for diversity and inclusion, I think there's still a lot of resistance on the leadership and on the people overall, because they all come from the same background. They have similar educational background, regional background, and they kind of still, the Korean society is still not very diverse. So there's recognition, there's lack of recognition for the need for more inclusion and not so much leadership on the action either.
Perfect. And to finish, what about as to mental health issues? Are there any notable developments or trends about it?
I think on mental health issues, I think it's interesting. In recent years, there has been a lot more awareness on mental health, like work-life balance and generally mental well-being in Asia, in Korea, for example, and other countries as well. So in the past, I think people thought that there was some stigma associated with seeking mental help or addressing mental health issues. So there's some hesitance and lack of openness about these issues. But in recent years, there has been a lot more openness from the public, and from public figures or celebrities, and people in general are more open about these issues. So I think now there's a general recognition that it is mental health is also part of our life, part of our physical well-being, and that has led to a lot more openness and discussion regarding treating and addressing mental health issues. So there are quite a few companies these days, and also law firms, that offer mental health programs or initiatives such as mental health counseling programs. And I think those programs are seen as a benefit, something to be, benefit to employees and something to be praised about, because it stems from the recognition that we are all living and working in a stressful environment, and this is a tool for coping with stress and maintaining and promoting your health and well-being. So I think that also is kind of in line with the cultural and global trends regarding health, seeking health and promoting health. And I think first, this is a lesson for diversity as well, like, in promoting diversity, that, diversity in broader perspective promotes health and well-being in general for everyone involved. So I think it creates a healthier and more robust environment and society.
Perfect. Thank you, Julie. I know it's already 11, sorry, 11 is in Brazil, so we're almost finish our time, but I think we have, maybe if you don't mind, we can reply to 2 questions if you don't mind. It's okay for you. So as Julie is the last one, we have a question to you. I'll read it and then you feel free to answer. Do you think Korea and Japan's relatively slow take-up of DNI initiatives, as influenced by political leadership that tend to be male-dominated in an older age group, perhaps LSS open to engaging with evolving societal norms? I'll just put the question again here so you can read it.
Yes, that's definitely a part of it. The leadership politically, the political leadership, as well as in large corporations, the leadership dominated by senior men, and the current, the administration, the former administration, they were all pretty much dominated by older men, and so there's a even despite the effort, the leadership definitely has been somewhat constrained in terms of diversity. And I think the country will benefit from more diverse opinions, more diverse leaders, but that has been difficult change to come about.
Thank you, Julie. We had 2 questions regarding US. Cedric is like amazingly replied to them in the Q&A box. But I think, Lisa, could you like talk a little bit about one question? It's how about organizations continue to promote diversity if they cannot explicitly consider race or ethnicity in their programs? So just a quick answer.
Yeah, just real quick, I think what we're seeing law firms do, it goes back to one thing, Jag mentioned about reframing, how you refer to DEI efforts. What a lot of firms are doing is focusing on inclusion. What they're doing in terms of their hiring practices to try and get more diverse individuals in is coding resumes and taking names off, and then also asking applicants to submit stories or statements on their perspectives, their backgrounds, and their life experiences. So as you see, firms like Latham Watkins will say on their website, we're interested in people with diverse backgrounds, perspectives, and experiences. And the way that they're getting diverse individuals in is by using those types of statements. So that's what we're seeing a lot of firms do, is coding resumes, taking the names off, and then asking for these personal statements about their life experiences, and using those to try and hire more diverse individuals.
Perfect. For sure, if you have any more questions, feel free to reach one of everyone from the panel. They will be more than happy to answer all your questions. And regarding our time, thank you to everyone who joined us for today's session, and a special thanks to our panelists for sharing your thoughtful, honest, and nuanced perspectives. As we've seen, legal rulings may shift policy, but they don't erase the need for equity, representation, and inclusion. The role of each of us as legal professionals, employers, mentors, and advocates is to find lawful, ethical, and human-centered ways to sustain these commitments. We encourage you to stay engaged, ask questions, and continue this conversation within your firms and communities. I would like you to remind you about the 2025 AIPPI World Congress that will happen in Yokohama, Japan. The registration is open till 31st August, so don't miss the opportunity. In that event, the DNI committee will have two small events. It's DNI Initiative Committee meeting on the 14th September, and the AIPPI Café 10, bringing diversity and harmonization. We will be more than happy to welcome you there.